Okay, this will be 200 jury charge. Members of the jury, I will now explain to you your duties as jurors. It is vital to the administration of justice that you fully understand and faithfully perform these duties. It is my duty to determine all of the law applicable to this case and to inform you of that law by these instructions and by the instructions that I will give you after all evidence has been received. It is your duty to accept and follow all of these instructions as a whole, not accepting one or more of these instructions and disregarding the others. It is your duty to determine the facts of this case from evidence produced in open court. It is then your duty to apply the law as determined by the court to the facts as determined by you, and thus render a verdict. You should not allow sympathy or prejudice to influence your decision. Your decision should be based upon probabilities and not possibilities. It may not be based upon speculation or guesswork. The evidence which you are to consider consists of the testimony of the witnesses, the exhibits, if any, admitted into evidence, any facts admitted or agreed to by the attorneys, and any facts which I instruct you to accept as true. The term witness means anyone who testified in person or by deposition, including the parties. The production of evidence in court is governed by rules of law. From time to time, it may be the duty of the attorneys to object to the production of evidence and my duty to rule on these objections. If I say the objection is sustained, you must not consider the testimony or exhibit covered by the objection. If I say the objection is overruled, you may consider the testimony or exhibit covered by the objection. The attorney's objections and my rulings upon these objections, together with the reasons for these objections and ruling, are not evidence and should not be considered by you. The statements, remarks, and arguments of the attorneys are intended to help you in understanding the evidence and applying the law, but are not evidence. If any statement, remark, or argument of an attorney has no basis in the evidence, then you should disregard it. You are the sole judges of the believability of each witness and the value to be given the testimony of each. You should take into consideration the witness's means of knowledge and opportunities of observation. Also consider the reasonableness, consistency, or inconsistency of the testimony. You should also consider the bias, prejudice, or interest, if any, the witness may have in the outcome of the trial, the conduct of the witness upon the witness stand, and all other facts and circumstances that affect the believability of the witness. My rulings and remarks made during the course of this trial are not intended to indicate my opinion as to the facts. During all recesses while this case is in progress, you must not discuss this case or anything about this case with anyone, and you must not allow anyone to discuss it with you. This rule applies not only to court employees, the attorneys involved in this case, and others you may meet in the courthouse, but also to your husband or wife, other members of your family, your friends, and anyone else you may meet. If during the trial anyone talks to you or tries to talk to you about this case, you must immediately report it to me or the clerk of the court, who will report to me. Do not, before this case is finally submitted to you for a decision, talk to your fellow jurors about this case or anything about this case, or form or express any opinion about it. Do not read newspaper reports about this trial, and do not watch or listen to television or radio reports about it. The reasons for these rules are that it is essential that you should keep your minds free and open at all times throughout this trial, and that you should not be influenced by anything except the evidence you hear and see in the courtroom. From now on, at the beginning of each recess, I will refer to these instructions as my instructions or my usual instructions. But whether or not this is done, you will carefully observe these rules at all times. It is now my duty to further explain your duties as jurors and to further inform you of the law applicable to this case. It is your duty to faithfully perform your duties and to accept and follow all instructions of the law as a whole, including the instruction I gave you at the beginning of this trial and the instructions I gave you during the course of this trial. You are not free to accept and follow one or more of these instructions and disregard the other. A written copy of all instructions will be given to you before you begin your deliberations. During the course of the trial, certain testimony has been presented to you by way of deposition, consisting of sworn recorded answers to questions asked of the witness in advance of the trial by one or more of the attorneys for the parties to the case. The testimony of a witness who, for some reason, cannot be present to testify from the witness stand may be presented either in writing or by way of a videotape while the witness is under oath in the form of a deposition. Such testimony is entitled to the same consideration and is to be judged as to the credibility and weight and otherwise considered by the jury in the same way as if the witness had been present and had testified from the witness stand. In a civil lawsuit, such as this one, there are requirements as to which party is to prove to you certain things. This is called burden of proof. When I say that a party has the burden of proof on any proposition, or use the expression if you find or if you decide, I mean you must be persuaded, considering all the evidence in the case, that the proposition on which such party has the burden of proof is more probably true than not true. Jurors, the instructions in this case I accept will take between 20 and 25 minutes would be my estimate, I think. Why don't you refill your cups, those of you who are refreshing yourself with that ice water that's available. Stand and stretch if you wish. I think we will move right into that now without further recess. Jurors, during the course of these instructions, I will be explaining to you in some detail the respective duties of the court, counsel, and you, the jury, in the trial of this case, and some particular instructions to assist you and guide you in the course of your deliberations. I will also be giving you very specific and particular instructions with respect to other points of law to be applied by you, the jury, to the facts as you find the facts to be in this case. It is your obligation at this stage of the trial to be attentive, as I am fully confident that you will be, to carefully listen and assimilate to the best of your ability these various instructions on the particular points of law to be applied by you to those facts, in order to allay any concern that you might have about individual and collective ability to fully assimilate all of this information and apply it accurately to the facts as you find the facts to be. I'm going to tell you now that there will be made available to you during the course of your deliberations a copy of the instructions that I have assembled and from which I will be reading now when I am giving you the instructions to be applied to this case.